Hi everyone, you're so welcome to this discussion today. My name is Donna Lyons and I'm with the Trinity College Dublin School of Law. This is seminar 5 in our law school speaker series. I'm speaking with Professor Cass Sunstein today, and I'll introduce Professor Sunstein in a second. Just to say thanks so much to the law school. Thanks to Connor Casey, to Oren Doyle for helping with this, and in particular to Tri.CON, the Centre for Constitutional Law and Governance, which is a research centre in the law school headed up by Professor Cavanagh. And my good friend Aileen is here today and will ask a few questions. So I'll speak a bit more about that later. But without further ado, Cass Sunstein is, as you all know, Robert Walmsley University Professor at Harvard and former administrator at the White House Office of Information and Regulatory Affairs. Sorry, was, yes, former, I did say that, okay. He is chair of the World Health Organization Technical Advisory Group on Behavioral Insights and Sciences for Health, a prolific writer and winner of the Hallberg Prize, as well as an author of many books, including How Change Happens, co-author of Nudge, Improving Decisions About Health, Wealth and Happiness, and more recently, Too Much Information, which we spoke about on the 11th of September this year. And today we're going to talk about Law and Leviathan, Redeeming the Administrative State, which is co-authored by Cass Sunstein and Adrian Vermeule. So Professor Sunstein will give a 10-minute overview, and then I'll ask a brief question, and then I'm going to bring in questions from all of you. So feel free to put your questions into the Q&A text box at the bottom, and we do have to finish up after an hour. So over to you, Cass.
Hey, great. Thank you so much. And it's an honor and a thrill to be able to discuss this project. The rule of law is always important, I think. Goes back to the Garden of Eden, though it may have particular urgency in 2020. So the goal of this project, and credit to my great friend and co-author Adrian Vermeule for working with me on it, is that there are two things in the world today that are pressing hard on rule of law concerns. The first is that all over the world there are countries which either by tradition-ish, that is for a significant amount of time, or by contemporary pressures, are leaning hard in anti-rule of law directions. You can use the word authoritarian, that's not unfair, though it's a little more abstract than anti-rule of law, which is the focus. But nations that do not obey the rule of law, that are troubled by the rule of law, that want to evade the rule of law are visible, and it's not hard to name names. The other direction is that in some nations there is an incipient or maybe growing sense that the deep state or the regulatory state or the administrative apparatus of government is a big problem and something should be done about it. And what ought to be done about it might be to undermine it or to put it in the hands of political actors, that is, who run for office, or might be the thing to do about it is to obliterate it. And these two tendencies, as I've described them, are relatively extreme. They can be found in more modest forms in, I think, every nation, and they have, in more modest forms, either real effects or very strong effects. Okay. The idea here is that there is a conception of the rule of law which is maybe more confined and more concrete than the conception that even lawyers often work with, that can ride like the cavalry on a horse, if not to the rescue, at least to the aid of beleaguered nations struggling either with incipient or real authoritarianism, or with an attack on the administrative apparatus of government. And the work on which this argument relies doesn't involve the administrative state at all. It's work in jurisprudence from a legal theorist named Lon Fuller, who over 50 years ago offered a remarkable and gripping and funny, I think, even account of how legal systems failed. So what Fuller imagined was a leader with the not coincidental name Rex, who was hapless, meaning, kind of a ridiculous ruler who kept trying to do things, and he kept failing because he kept failing to create a rule of law. He tried to be a ruler, but at every turn he was unsuccessful because he couldn't. He didn't know how. And the failures of the rule of law, which could be told in narrative form, culminate in something that is more in terms of principles. And the idea is that a rule of law is non-existent if a legal system does one of 8 things. And what I'm hoping is that each of the 8 things won't be mere abstractions, but will be, and this is not a wonderful thing, it's just a truth, will be part of the lived experience of every citizen on the planet, meaning at least once you've been a victim or an observer of one of these failures. And this is true in China and in Russia and in Cuba. It's also true, much less extent, but it's also true in Ireland and Canada and France and the United States. So here are the failures. First, a failure to make rules in the first place so that issues are decided on a case-by-case basis. We are sometimes in a Kafkaesque situation in which an authority isn't bound by rules. The second is a failure of transparency in the sense that we are not made aware of the rules with which we must comply. It might be that they're so complicated, it might be hard to know what they are. It might be that they are in one or another sense hidden in a bureaucracy and so inaccessible, say, to a small business or to someone who's suddenly accused of violating the criminal law. There might be an abuse of retroactivity in the sense that people can't rely on the current rules and under threat of change. So what was fine on Tuesday is not fine on Saturday. That's an abuse of retroactivity. It might be that rules aren't understandable. They are shrouded in such jargon and complexity that ordinary people can't figure them out. And in Washington, I heard that objection repeatedly in a democracy, the United States, where people said, we don't know what you are prohibiting and what you are allowing. The fifth failure is an issuance of rules that contradict each other. So the tax authorities might say you must do this in one provision, and in another provision say you can't do this. That's a violation of the rule of law. It might be that people are required to do things they lack the power to do. So a small company might be required to do something and it just can't. It doesn't have the resources or the capacity. It might be the rules are changing so fast that people can't orient their action in accordance with them. So things are so rapidly shifting that we don't quite have retroactivity. It's not that people are punished for something they did which was lawful at the time, but that the speed of legal change is so severe that for people to orient their behavior in accordance with these things just isn't possible. And last but not least, in some ways most, there may be a mismatch between the rules that are announced and the rules that are administered. So that the authorities on the ground in, let's say, Dublin or New York City or Paris or Moscow or Berlin might not be acting in conformity to the rules that are on the books. Okay, Fuller, writing against the background set by fascism and communism, said that if the government fails in any of these ways, it fails to have a legal system at all, except maybe in the Pickwickian sense, in which a void contract can be said to be one kind of contract. Okay, what's enduring in this account is the suggestion that law has an internal morality, a morality that is distinctive to law as such. And this is a very specific idea. A legal system that does not respect freedom of religion or freedom of speech might still be a legal system. A legal system that is full of interference with free markets and is doing all sorts of things that former University of Chicago people like me are alarmed by, meaning University of Chicago, we kind of like free markets. A government that's doing those things might be acting consistently with the rule of law, so as long as it obeys the 8 principles. Okay, the basic idea that is the motivation for this project is that the administrative state can be and should be disciplined by the internal morality of law. And a project in the works in many countries, sometimes it's intuitive rather than explicit, is the morality of administrative law, by which these principles are brought to bear on and concretized in the context of judicial oversight of the administrative apparatus. Now, if we have that, we don't have, a full answer to the 2 sides with which I began, those that are acting in an authoritarian way or tending in that direction, or those who are alarmed by the existence of a big administrative apparatus. We don't have a full answer, but we have a component of a resolution that can create outcomes that are of immense human value. So the suggestion is the internal morality of administrative law is a worthy and even inspiring ideal. And while it doesn't promise to deliver everything to citizens who are alarmed by the administrative state and want to dismantle it, or to leaders who are excited about their authority and want to have more of it, doesn't deliver full answer. It does deliver something of a corrective to the fears and the threats posed by regulators in all their forms. Thank you.
Thank you so much. That's so interesting, and it leads well into my first, my only question. But you probably have actually answered it. But I'm really interested in this idea that you explore throughout the book of the internal morality of the administrative state. So you've got 3 long chapters on law's morality. One on rules and discretion, one on consistency and resilience, and one on limits, trade-offs, and the judicial role. And there's too much in that to discuss in the 1 hour, but I was just wondering if I could read a brief quote about the internal morality that you mentioned, and then just ask you whether you might tease it out a bit more. Would that be all right? Okay. So you mention Ronald Dworkin, Lon Fuller, HLA Hart, and you've gone into Fuller's 8 principles in detail just now. And then on page 42, you say that instead of doing jurisprudence, we aim to repurpose the morality of law, referring to yourself and Professor Vermeule, bringing it into sustained contact with long-standing debates in administrative law where we think it is most pertinent. Our largest suggestion is that an understanding of the morality of administrative law helps to unify a disparate array of judge-made doctrines of perhaps even the field as a whole. So then on pages 143 to 144, you talk about the central claim in the book, which is that at its best, American administrative law has its own internal morality, a reflection of the internal morality of law. And later on, you say that that should be celebrated, and that's something that you've discussed just now, but I was wondering if you wanted to tease out a bit more, maybe for the skeptics or for the students on here who haven't yet studied jurisprudence as part of their degrees, just why should that be celebrated based on the context legally that we're in at the moment?
Okay, thank you for that. So suppose you have an agency, part of the government, that issues a regulation involving the environment or involving occupational safety. And then suppose the agency decides in a particular case that it doesn't really like the regulation, and it's either going to be punitive to someone who's not maintaining a healthy enough workplace, or lenient to someone who is maintaining a healthy workplace. And then the rule is compromised. Okay, the problem is that the value of accountability and stability has just been crushed. And people's ability to plan, whether they are workers or employers, has just been obliterated. And that's a grave wrong. So maybe I'll tell you a story. Sometimes stories are better than accusations. So I had my car stolen in Chicago a number of years ago when I lived there, and a police officer found the car. And as I walked with the police officer, he asked me what I did for a living, and I said, I teach constitutional law. And he looked unhappy. He looked grumpy. And I said, is the Constitution a problem for you? And he kind of smiled a little bit. And I said, do you ever violate the Constitution? Is that the problem? And he got a big smile on his face, and he said, oh no, I never violate the Constitution unless I say I violated the Constitution. And I never say I violated the Constitution. You can think that conversation was, for me, the inspiration for the book. He was saying, basically, I violate the Constitution all the time. I don't like the Constitution, but I never say I violated it, so I never get in trouble. And that's, he was a good guy. He found my car. In my experience of him, I liked him. But that's not a good thing for someone to bypass the Constitution. And if we're thinking about anything that a department or ministry does, public officials do, to give people clarity about what the rules are is essential. I was also in China a number of years ago, and I taught the rule of law a little bit, some stuff that ended up in this book, actually. And my Chinese students, who were in their 30s and 40s, they weren't youngsters, they were all members of the Communist Party. Their eyes lit up. They got a sense of magic that I did not anticipate. And I said to one of them privately afterwards, why was that class on the rule of law? And they read Fuller. Why was that so electrifying for you? And they said, in China, this was a number of years ago, it's no longer true. If it's not specifically allowed explicitly, it might be punished. And even if it is explicitly allowed, we can't rule out the possibility that it will be punished. And that makes life, my friend told me, terrifying. And to see a legal system where that can't happen that's much more charged in a good way than you, Professor Sunstein, expected.
Thank you so much. That's interesting. And we have Conor Casey here, Dr. Conor Casey, who is a postdoctoral fellow in the Max Weber Institute in Florence, and he has a few questions for you. So I'm wondering if you can hear us, Conor. Just to say, Matt, Conor is postdoctoral fellow at the European University Institute and did his undergraduate and doctoral studies at Trinity College, as well as having a master's from Yale Law School. There you are, Conor. Go ahead whenever you're ready.
Thank you so much, Professor Sunstein. Many thanks for your presentation, and to both yourself and Professor Vermeule for your excellent book. As a big fan of both your work, this is a real treat for me. So just two questions, if that's all right, Professor. So the first is, so you can see some of the genesis of some of the book's main themes, I think, emerged around 2015, when a series of articles yourself and Professor Vermeule responded to the so-called New Coke libertarian administrative accounts of the administrative state, and they emphasize its dangers to political accountability and liberty. So just wondering what spurred publication, sort of distilling those arguments into this book at this time, because critics like Randy Barnett or Gary Lawson have been airing these concerns for decades. So is it contemporary concern that these new Coke ideas might percolate into the political mainstream and have downstream consequences, or perhaps that the views of Justice Thomas or Gorsuch in curbing Chevron and our might lead into the rest of the court? Is that the sort of driving force?
Thank you for that. So I imagine you, Connor, and Professor Lyons, and basically everyone who's listening, sometimes you feel with respect to an idea, you have a tiger by the tail. And you know, it's big and it's fast and you're weak and it's running and you got the tail. And my feeling, as Professor Vermeule and I were working on this, was we had a tiger by the tail. And I love that feeling. It's one of the best feelings in life, I think, even though you can't keep your balance. And the reason, I'm just speaking for myself, I wanted to do it was that the idea that the administrative state can have a kind of legitimacy in it that the American critics were skeptical of, it didn't have anything to do with the United States in particular, or it wasn't limited to the United States in particular, or it didn't have anything in particular to do with a North American debate in 2002 to 2020. It had to do with something much bigger. And so Fuller, the jurisprudence guy, had an account of the morality of law, which I think has largely been lost in English-speaking countries, and it's basically never been found in non-English-speaking countries. And its current resonance in terms of both principle and practice is in an area that Fuller didn't even study, which is the administrative state. So the idea that, you know, in Brazil or Colombia or Russia or Thailand, these are ideas that are you know, of value. They're not everything, not close, but of value. That's the tiger. And so once we saw, after we'd done these, you know, law review pieces, that the large theme was really an international theme, and it really speaks to, and you know, as my experience in China a long time ago, I found in the last weeks, a kind of clarity about the specification of the rule of law that completely outstrips at least my thinking, because the clarity involves concrete things that are happening on the ground to people all over the world. To get a hold of that was at least my goal.
Thanks so much, Professor. Just one more question, if that's all right. You mentioned on page 71 that those hostile to the administrative state are often convinced, and this is they're convinced that, and this is the quote, the idea that agencies can interpret their own regulations as a recipe for authoritarianism, end quote. So that read very interesting to an Irish audience, I think, because in Ireland, one of our absolute bedrock principles is that statutory interpretation is absolutely only a matter for lawyers and judges. So it would be effectively heretical to advocate for something like Chevron or deference. Even the most sort of liberal Irish lawyer who's sanguine about a redistributive or regulatory administrative state their views on statutory interpretation would be on all fours of Justice Thomas's views, for example. So I was wondering, what would you say to convince an Irish lawyer of how doctrines like Chevron they're not on balance a threat to the rule of law, but can actually contribute to good government?
Okay, so I wish I knew more about Irish law than I do. I think the debate you're pointing to, it's a debate among good friends, not only in general, but with respect to the law. That is, those who like Chevron, and let's say in the United States, and those who don't like it, let's say in Ireland, they're really close. It's a very tiny debate. And let me explain why. So, and then I'll get to your question. So the Chevron view is, suppose you have a law that has a word like source in it, or a word like modify in it. And let's suppose the question is whether the word source applies to a whole plant, or does it apply to a specific smokestack? Or whether the word modify allows for a very significant change or only an incremental change. Now, people who like Chevron agree with people who don't like Chevron that if the text has a clear meaning in context, the view of the agency is utterly irrelevant. So suppose you know in context that modify just means incremental change. It doesn't mean transformation, change. Then the agency is bound. Or let's suppose the word source in context, it just has to mean the plant, not the smokestack. Then we're done, we agree. Suppose the legal sources run out such that the word source, you just have no legal materials to tell you. Or suppose there's a word diagnosis in a regulation, a diagnosis of lung cancer. And let's suppose different doctors have different views about what a diagnosis is. Then the pro-Chevron people say, look, if you have a term where really it's ambiguous in the sense that the legal materials run out, better to have someone who knows something, like a specialist on what counts as a diagnosis, or better to have someone who's politically accountable, who can make the choice between a plant-wide and a smokestack definition of source. And to have unelected judges making that decision where by stipulation we don't have a purely legal resolution is a good idea. So here's a way to put it, I guess. Let's focus on the diagnosis question. Do you want judges deciding what's a diagnosis when that isn't a legal term of art? It's just a word that meant, figured out. Or do you want the people who actually know something about diagnosis? Or if there's some word, let's call it the word harm for an endangered species. And the question is whether you, if you reduce breeding areas, are you harming an endangered species? And you're not hurting any member of the species, they're fine, but you're making it harder for them to breed. Is that harming them? Let's just say that the text in context doesn't give you an answer to that question. Do you want judges saying what harm is? Or do you want people who are specialists and who are ultimately accountable to the people? So I have a reckless speculation, which you can correct me on, or someone can do a research project on. My speculation is that in Irish law, in a case like diagnosis or harm, on the ground, agencies are winning those cases more often than they're losing. And there's some principle somewhere that sounds a little like Chevron. That's my speculation.
Just briefly, your Irish courts sort of draw the distinction that you yourself and Professor Vermeule rebut in the book. The neoclassical framework would map on very well to Ireland. So sort of a Chevron deference to policy discretion, but a sort of formalist de novo review of statutory. But I would agree with you that the boundaries are very blurred when it comes to that.
Right. If you have a word like diagnosis, the question whether the choice of what sort of opacity on an X-ray counts as that, you can describe it as a policy choice, if you like, and then defer to the agency. But then you are really moving toward the Chevron framework, just under a different and possibly preferable semantic. So the thought is, Chevron doesn't mean that ambiguities are resolved by agencies. It means something more like if the legal materials really run out and the agency makes a reasonable choice, then it prevails. So to reject that, as Justice Thomas does, isn't, in my view, horrifying. We're all on the same team here. I don't agree with him, but we're all on the rule of law team.
Thanks so much, Professor.
Very persuasive. Thanks, Cass. Thank you, Connor. We will probably come back to this issue, I imagine, in the Q&A. But just to bring in Professor Adrian Cavanagh here. So Professor Cavanagh is Professor of Constitutional Governance at Trinity College, Dublin School of Law, formerly a professor at Oxford, and is head of the Trinity Centre for Constitutional Law and Governance, which is a research centre in Trinity College School of Law, which aims to provide a hub for national and international scholarship on all areas of public law, broadly conceived, including constitutional law, administrative law, and comparative studies. Very relevant to what we're talking about today. It also forges links with Northern Ireland and the UK in a series called Constitutionalism Beyond Borders, as well as a series called Constitutionalism Beyond the Courts, which ties well into some of the issues that come up in Law and Leviathan. So go ahead, Aileen, whenever you like.
Great. Can you hear me?
Yes.
Great. Thanks, Donna. Delighted to have you back again in Trinity and in Tri.CON. We're delighted to have you, and many thanks to Donna for setting up this great series. And I have the book here. I don't know if you can see this with my background, but I'm a proud owner of the book. So two just brief questions which struck me when reading this book. And the first is, what would you say your experience in the White House brought to your appreciation of administrative law, and whether that changed your view on the propriety of judicial intervention in agency decisions? Was there a kind of before and after, and what was the after? The second question is related, and that goes to the issue which we haven't spoken about yet, but which features in the book, which is your discussion of what you call surrogate safeguards. So that was really interesting to me because I've spent many years teaching in the UK, and I've taught administrative law in the UK. Your prediction about Ireland on Chevron would be absolutely the case in the UK, right? That on the diagnosis issue, the agencies will win that case almost inevitably. So there are strong doctrines of deference in UK law. So therefore, what you describe as the second best in the UK and UK administrative law would not only be the main vehicle for judges to look at decisions made by agencies, but in fact it would be perceived to be first best. When judges depart from various assumptions of deference and are highly interventionist, in the UK way of thinking, this is second best because it's dangerous. There's a danger of usurpation. So I wondered whether you could speak to those 2 points, which I think are related, and it would give a bit of context to the American debates.
Okay, great. Thank you for those. They're great questions, and you have the best background in the history of Zoom. So we talked about this before. Nice to see you and the background again. So,
thank you.
So let's talk about surrogate safeguards and second best. So you might think either that deference to agency interpretations of law in the face of ambiguity, let's call that the UK approach, is first best. Or you might think, if you adopt, I gather, the Irish approach, that it's second best, and then we could debate that. By second best or surrogate safeguards, we mean something much more macro. So there's an idea afoot, which German law has in it, and some nations do, which is that if administrators are given open-ended discretion, it's unconstitutional because it's an abdication or delegation of legislative power. So if Congress says, or a legislature says to the Environmental Protection Agency, do whatever you deem best to counter climate change, that would be, on one view, an unconstitutional act. Does Irish law have a non-delegation doctrine in it? Muted. Okay.
We're both on mute. Let me bring Connor in on this. He's an expert. Hold on a second.
Let's just bracket that. I'll get to the questions.
We'll bring Connor in a second.
So some legislatures have these, are constrained from granting open-ended discretion, and many people think that the infrequent enforcement of that principle is horrible. So the idea of second best or surrogate safeguards means that whatever you think about the constitutional ideal, the rule of law values are surrogate safeguards. they achieve some of the goals of accountability, liberty protection, and so forth, even if the first best, by some accounts, aren't achieved. So we don't mean to say that any particular principle is better than a reasonable alternative, or worse, but instead to say that the whole framework of the morality of administrative law can be seen as a surrogate safeguard for other more nuclear, let's say, principles. Okay, so instead of striking down the Clean Air Act, which some people would do as a first best, we have surrogate safeguards, meaning those administering the Clean Air Act have to obey the rule of law. Okay, I hope that was clear. In terms of my White House experience, I have two different lessons that I got from it. One is the immense importance of respect for legal constraints by the executive branch of government. So I oversaw federal regulation, and there were many times when people who had a passionate political view or policy view would want to do something, and the lawyers would say, you can't. And I was a lawyer and am a lawyer, but I wasn't the lawyer. My role was a policymaker, and I was able to ask the Department of Justice frequently, what is our space here for policy movement? And the Department of Justice would say frequently, you don't have a lot. You can't do that. And to be told no is often not the best thing to hear, but I love that because it was the rule of law in operation, the lawyers asserting the supremacy of law. And that is great. Whether the president is right of center or left of center, that is a precious thing. I do think occasionally under, this is not a political talk, but occasionally under the current president, the Department of Justice has not said no enough, and they've lost in court. So there's that. On the other hand, I did have, in a way, less enthusiasm for judicial scrutiny of administrative action after my White House experience from the following perspective. People often work for months and years on, let's say, something involving labor, protection of labor from, let's say, safety problems. And they see, 40 options, and they debate for months. Do you do this one or this one or that one or that one? And they see the benefits and the disadvantages of each. And then they ultimately choose, often very responsibly, one. Then a smart lawyer will be able to make the administrators look stupid or neglectful by saying in court they never considered this or they didn't adequately consider this. And it's credible, but it's not true. Because the people, 70 people maybe spend weeks poring over exactly that issue, and they understand it so much better than the court can. And the government's lawyer, who will be maybe my good friend, is someone who had no participation in the process, who has no clue about what actually happened, who barely understands the problem of, let's say, silica, which is a carcinogen of the workplace. And then the lawyer has to defend the government. And this person's an outsider. And the lawyer on the other side is very much an outsider. And the court is an outsider. And so it's not infrequent. It's not frequent, but it's not infrequent that the court will strike something down as arbitrary or unreasonable, where none of the legal graduates in the case knows anything about the problem. I'm thinking of one case in particular where a mercury regulation was struck down by the Supreme Court of the United States. And I admire them all. They're all really smart. And they spent probably, each of them a good week on the problem. But people equally as smart had spent a year on the problem.
Yeah, thanks.
Thanks so much, Aileen. Thanks, Professor Sunstein. I'm conscious that Tom Hickey is also on the line. So yeah, in terms of a non-delegation doctrine, we do have one, but it's a little bit complicated. And I know Oren Doyle and Owen Carolan would have a lot to say about this. I'm not seeing them on the line, but Tom might even come in. But Connor is a specialist on these issues. So I'm not sure if you wanted to say anything about that, but no pressure, Connor.
Just very briefly, it's very similar to the American doctrine. We actually adopted from American case law in the New Deal era. It just requires that there's some principles guiding the delegation of rulemaking power. So it's very similar to the intelligible principles case.
Great.
Thanks, Connor. Sorry to put you on the spot there. We have a question in the Q&A. I might bring that in there, if that's okay with everyone. So Rafi Resnick asks, why the reference to Hobbes in the title? Right, sorry. So yes, okay, not specifically Hobbes, but Leviathan. Is the Leviathan analogous to Cromwell and the deep state and unaccountable expert administrators, or is it analogous to a Fullerian Rex? In other words, do you vindicate the Leviathan, or do you propose how to overcome it?
Okay, great. So you can see Leviathan in the title as both an implicit effort to rebut Hobbes, who thought of a all-powerful sovereign, and also as an effort to respond to the more intuitive and less academic sense that the government is a big whale and the Leviathan needs to be constrained. So the subtitle is Redeeming the Administrative State. So this is in the book, though it's not the main theme of the book. To me, it's very important, and I think to Professor Vermeule also. So in many countries, the deep state or the accountable expert administrators are under siege. Let's take that line of attack on them. To my White House experience, I worked with them every day. They're not being paid a lot of money. They typically have no discernible political view, but they might be concerned with making sure that the food supply is safe. And that's what they've done maybe for 25 years. That's what they've dedicated their life to. They're not very sentimental people, but they know a lot about how to make the food supply safe. That's what they do. And to treat them with disrespect or contempt, or to act as if they are, unaccountable, bad people, they obey orders. That's part of their self-understanding. And they also have a legal statutes to pay attention to, and they treasure that. And they're not paid enough, and they're not given enough leisure time, but they are heroes. And to dispense with them would be reckless. To treat them as enemies of the state would be worse than reckless. And so part of the goal of the book is to say that for those nations in which people do engage in these behavior, these jobs aren't being honored or being treated as a threat to democracy and liberty is worse than unfair. Having said that, there are people who are engaged in administrative roles who are genuine threats, let's say, to small businesses or to people's ability to plan, or to people who are accused of crimes, or people who are trying hard but not fully succeeding in obeying the tax laws. And in those people, the rule of law is, at least in part, a cure for what ails us. So the dialogue with Hobbes, maybe I'll say a little bit more about this because the question is actually a deep question, is to say Hobbes was quite wrong in seeing an unlimited sovereign. I can say, speaking just for myself, not for my co-author, Carl Schmitt is a very influential theorist of the state. And he was an extremely intelligent person who was also a Nazi. And exactly how to think about his Nazism is an interesting question, and different people have different views. Putting, historical, biographical assessment to one side, the idea that that ultimately a very powerful executive should and must exist is incorrect, and it's too simple. It's also incorrect. That the rule of law, as the internal morality of administrative law understands it, is both an essential constraint of the operations of the executive. And here this is true in free countries that are basically doing well as in unfree countries where horrors are. And the idea of the rule of law is also a facilitator often of good executive action as well as a constraint. So it's both. If you want to be an effective executive, you're better off if the laws on the books operate as the laws do in the world in general, because otherwise people are going to be disaffected and not know what is okay and what isn't. And if they don't, they're going to do a lot of things that aren't okay. So the executive is often benefited by being forced to obey a lot of stuff which seems day-to-day annoying.
Thanks so much. That was a good question. Thank you, Rafi, and thank you so much for the really interesting, lengthy response. These are really crucial issues for our time, and I think that there are no further Q&A questions in the text box, but I'm sure there are people there who have questions. I'm seeing Tom Hickey and Roisin Costello. Feel free to raise your hand if you do have any questions. But I know that Conor Casey would like to come back in the absence of any other questions. So I'm going to promote you to a panelist again there, Conor. And if we have time, we might get another question from Aileen as well. Okay. So
I know there's a new statute requiring that on Zoom sessions, every person ask at least one question. It's true.
Around the table, kind of.
It came actually from Brussels, but it's somehow binding on all the world. So those of you who are in breach, you really want to obey international law here.
That sounds really good. I'm going to get working on that today. Work away, Conor.
Great. Professor, just wondering, Justice Kagan, now Justice Kagan, wrote an article a few years ago.
Sorry.
We have a censor. Someone's censoring Justice Kagan.
Doesn't like. Apologies. That's entirely my fault. So, sorry, you were saying, Conor, Justice Kagan.
I always thought Kagan was very moderate, not needing censorship, but the article charted how the presidency has become more and more reliant on policy making through the administrative state as opposed to trying to get legislation through a gridlock Congress. Do you think that this will become more and more, that the policy making through the administrative state will become more and more aggressive, or do you think we'll see a real attempt at retrenchment and to curb presidential control over the bureaucracy a little?
Okay, so that's great. So let's think of, I'm very conscious that different countries might have different trend lines on this count. So what Kagan was principally interested in is there's an administrative apparatus that sometimes operates independently of the White House. So you could have people whose job it is, let's say, to focus on health insurance or on immigration, who consider themselves free actors. I was in a European country not long ago, I won't name it unless you really ask, and I talked to a minister there and mentioned that we'll give it away. The chancellor had a strong view on something. This was Germany. And the minister looked at me as if I was saying, some interesting person had a view on something, rather than my boss has a view on something, which surprised me. So in Germany, evidently, the ministers are not controlled by the chancellor, though they consider the chancellor's views interesting. What Kagan was saying was the ministries are controlled by the president increasingly, and she basically likes that. And so there's a trend in favor of greater presidential control over the apparatus of the administrative state. And it would be very interesting to do a nation by nation comparison to see how much of that we observe. It has some advantages in terms of accountability and coordination. So if you want the Department of Agriculture and the Food and Drug Administration to be marching hand in hand, then presidential oversight is a good thing. I think that trend will continue. If Vice President Biden is elected, it will be actually quite interesting to see if we see some stepping back from the trend as a reaction to President Trump, thinking to get the experts to do things immune from political oversight, let's say, might be a good idea. So the trend is generally likely to continue, but there may be some qualifications in the United States in reaction to President Trump if we have another president. With respect to the legislature as opposed to the executive action, of course, the presidential system is different from a parliamentary system where there might not be that kind of need for the executive to act. The way I'd put it is a little different from, I think, how most people would put it. It is true that our Congress is very frequently stymied by partisan division, so it doesn't do things. I wouldn't say that there's an increase necessarily in executive power in the face of the stymieing. There's a resort to existing legal authorities, which are often, here, let's use the word second best, compared to Congress. But the executive authorities just exist because Congress created them. So let me give you an example. A Democratic president or a Republican future president who's concerned about climate change would probably prefer to have some sort of climate change specific legislation on the ground that it's better adapted to the climate change problem. But the Clean Air Act now gives authorities to control greenhouse gas emissions, which are not first best, but which are available and better than nothing. So President Trump isn't nearly as concerned about climate change as President Obama was, but he's doing some things on climate change under existing authorities. And a President Biden would do more things under existing authorities as President Obama did more things. I wouldn't say that's an increase in presidential authority compared to Congress. It's more using existing authorities that are often not the best because Congress is stymied. And that's what we'd see under any president. So President Trump has done a bunch of things with respect to healthcare that are executive authorities because he can't get things through Congress. And basically President Trump isn't able to get things through Congress because the House of Representatives is controlled by the Democrats. And so he's using executive authorities, but they exist. He's not claiming, generally, there are some cases in which he is, but generally he's not claiming authorities he doesn't have.
Thanks. Yeah, thanks so much. On behalf of both of us, that was a really good question, Connor, and thanks so much for the answer. And there is one remaining question which I will ask, and I'm conscious that we have 5 minutes, but I think there's enough time given that you were able to answer 10 in a lightning round within about 2 minutes in the last session. So Finn Keys asks, so Finn says, the government in Ireland and also in New Zealand have recently been criticised and challenged in the courts for presenting COVID health advice as if it were legally binding. Has this been seen in the US, and how big a challenge does it pose from a rule of law perspective in your view? So that moves slightly away from what we were talking about, but it is an interesting.
I love that. I love that. That is part of the book and really important. Okay, so it has many different faces, this problem, and I'm just going to describe one face. So in some nations, to have a legally binding regulation, you need to go through some sort of process. And there's that. Then there's then there's guidance documents which aren't binding. If a guidance document purports to be binding legally, but it didn't go through the requisite process, it's illegal. And we've definitely seen that in the United States, where both Republican and Democratic agencies, or agencies under Democratic and Republican presidents, have issued guidance documents and treated them as binding. And that is a problem for the rule of law. Certainly, insofar as the law requires that you have to do something specific to make something binding, and that's being violated. So that's on the rule of law train. That's one of the seats.
Yeah, and that's a big issue that we faced here. And we have an observatory which has been set up to look at Ireland's response to the various measures being introduced. And that has been one of the big critiques of the responses. And as you said, Finn, just that vagueness, the very grey area between what is legally required and legally punishable versus guidance. And yeah, I think a lot of countries are facing that at the moment. Is there anything you'd like to bring in yourself, Professor Sunstein, before we finish up today? I think we haven't touched on, well, plenty we haven't touched on. But
I have one thing, yes, which is there's a lot of jargon in the White House, and the most ridiculous and most helpful is the same, which is the word do out. So in the White House, after a meeting or a discussion, often there'll be a do out, meaning something people have to do afterwards. So I have a guidance do out, which is to think of an area, everyone who's on this in this conversation, think of an area in which there is a incomplete or not respect for the rule of law in some domain that concerns you, and let's see if we can do something about it. That's our do out.
Couldn't be happier to hear you say that. That was wonderful. And thank you again so much. It really is an honor. It's a real privilege for us to have you twice in 2 months to the law school. You're very loved and respected in Trinity and beyond Trinity throughout Ireland. So as well as being a prolific writer, you're a very influential thinker. And it's great to talk about Law and Leviathan with you today, because it touches on so many important issues relating to state governance, democracy, rule of law, all of these crucial debates at such a challenging time for us here and in the US and globally, but it also offers a coherent message of hope and positive reflection for the future of the state. So thank you again massively.
May I thank you? So I like to consider myself an Irishman by marriage. I was married in Ireland, and in so many things in 2020, Ireland's a beacon for the world, and you know, we can name 20 dimensions, and to be able to talk to you all is a thrill.
It's very kind of you to say that. I'm not sure every Irish person would agree, but it's not the worst place to live. Thank you so much. We really appreciate it and hope to talk again soon. Take care. Bye.